Next from Springfield, we'll hear from state legislators, union leaders, and others affected by pension reform to get their reactions to the Supreme Court arguments. This runs about 15 minutes.
All right, Christina, so the pension case just let out. What are your initial impressions of it?
We heard once again that Illinois has a severe pension crisis. We've tried the route of higher taxes. In fact, 90 cents out of every dollar from the 2011 income tax hike went into the pension system, and yet they collapsed even further. So you heard the Solicitor General making a very good argument that yes, this is a contract, but contracts under certain circumstances can be changed to make sure we don't spiral into basically a suicide pact where more and more jobs and more people leave Illinois because they're not willing to put up with the spiraling costs of pensions.
Okay, and so are you saying that the contracts should be changed in the case of Illinois since the pensions are underfunded by $111 billion?
Absolutely, and you heard the Solicitor General say that this particular law, SB 1, really only tackles 1/5 of the problem. So if we can't even begin to nibble away at the edges, we're going to be in a world of pain in just a few short years. She made the point that this law does not erode the underlying pension benefits. It does change age and COLAs, but right now we have more than 8,000 state retirees earning six-figure pensions, more than $100,000 each and every year. We have 60% of the systems, 60% of the people are on track to retire before they turn 60. I mean, who does that in the private sector anymore? Retire on a six-figure pension before they turn 60. These are some of the reasons why we've got to change it, because it's just not sustainable anymore.
Okay, what about Attorney DeVito? He spoke about the language in the Constitution that said that the drafters anticipated a day like today. What do you have to say about that?
He made a pretty extremist argument. He basically said, come hell or high water, you can't touch pensions, which is pretty extreme when you consider that we don't know what kind of other financial and other crises that might confront the state going forward. So the idea that pensions should come first, that's not right. I mean, it's not a core government services. It's an important part of making sure that we have a well-educated, well-retained state workforce, but it's not the number one primary goal of state government.
Okay, is there anything else that you'd like to add?
Right now, we have 39 cents on every dollar we should have in the pension system. We socked all that money from that 2011 income tax hike into the system, and it got worse. What we need out of this court is for them to say not only is this constitutional, but other changes, such as moving future workers and current workers who go into work tomorrow into a 401k style system going forward, so the politicians cannot continue to mismanage the system. I mean, as long as the politicians are in control, they're going to play games. We're going to need this reform and others moving forward.
Okay, thank you so much for your time.
Thanks.
Thank you.
Herr Madoff, just coming out of arguing the case before the Supreme Court on the Pension Reform Act, what is your overall reaction to the arguments you've heard on both sides?
I felt that the state did not have answers to what we put in our briefs. I felt very good about the way the arguments went, and we got the critical points across. The state learned that nothing is absolute, that the Constitution cannot be absolute. That is of great concern to me. The Constitution is not a guideline, and that's what the state is asking for. And particularly when the state is saying, we now have this problem. It's a problem of the state's making. It's what I call the Lizzie Borden defense. Lizzie Borden took an axe, gave her father 40 whacks, and when she thought that she was done, she gave her mother 41. Please have mercy on me, I'm an orphan. That's really what we are talking about here. We didn't fund these things for all these years. In fact, in Sklodowski, we took $21 million out of the pension fund so that we could spend the money elsewhere, and now we have a problem, we can't pay it. That's not an acceptable answer to this situation.
What would you say to the argument that was made by the Solicitor General relative to, as I understood the argument, the pension clause, the diminishment clause in the Illinois Constitution, she was arguing was unconstitutional relative to the federal Constitution because it violated the sovereignty of the state by binding its hands, so to speak.
The state has cited U.S. Trust Company for the proposition that it cannot deprive itself of the police power. That's not what the U.S. Trust case says. It says that the contract clause of the U.S. Constitution is not absolute. It says that the state is not necessarily bound by contracts it makes. But it also points out in that same opinion that We have always held the state to its debt contracts. And that's what we're talking about here. Money is owed to people. So I think under an appropriate reading of that case, the state is wrong.
Let me throw this out relative to a debt contract. The state borrows a lot of money. It issues bonds. When you just brought that up, if for the sake of discussion, the Supreme Court upheld the law and that therefore the state could in effect renege on the contracts that it made with the state workers, would that in your estimation have any other implications, such as the obligation of the state, let's say, to be paying its bonds? Or could it use the same argument that under the police powers we're going to have to renege on our bond obligations?
That was the end of my argument. I pointed out in argument quite specifically that the state in its brief complained that it could have a problem with bad credit, with the bonds falling, if it can't deal with this situation. In its oral argument, the state said that that's an emergency situation it needs to deal with. For those who saw the end of my argument, they heard me say specifically that we have approximately a $50 billion market in Illinois bonds. If this court comes out with an opinion that says that the state can renege on those contracts by claiming police power, what is going to happen to that bond market? What's going to happen when everybody who holds those bonds suddenly realizes that the state may not pay on them? What does the value of those bonds become? I think that's a major danger for the state's credit, and I speak in terms of the bonds. But what about the construction company that says, I'm going to build something for the state, and suddenly says, the state may not want to pay me, so I want all my money up front?
All right, Dan, so the pension case just took place. What was your interpretation of it?
Well, I think we had a good day in court. I think, we made our case very strongly. The court will read our briefs, which I think are very clear and very strong. And I think their questions indicated that they're skeptical of the state's claim that they can undo the Illinois Constitution when they feel like it. And, we've always said the Constitution was written for this day. The words of the Constitution and the framers in the constitutional debate said this is the day they're protecting against, the day that the state would come and say, we want to cut pensions because we think there's a fiscal problem, and by the way, we created that fiscal problem.
Right, and there was a lot of discussion in there about the language of the Constitution and what the drafters thought of it, and that they foresaw that this day would happen. What do you think of that?
Well, the words are very plain, and as our attorney made clear, you look to the words of the Constitution. And I think it's very telling that when those words were submitted to voters in 1970 to approve it, the explanation that went out to the voters said this language is self-explanatory. Pensions cannot be diminished or impaired. It's not complicated. I was a high school English teacher. I'm very confident my high school students could read that language and tell you what it means.
Okay, and let's say the case goes back to the circuit court. What then? What is your opinion?
Well, I mean, if that would happen, we'd have to, read the decision and do whatever the court instructs us to do.
All right, so Senator Raoul, the pension reform case just let out. Initially, what are your thoughts of it? What was your interpretation?
Well, most of the questioning seemed to be focused on, wasn't this a problem that the state created, and how can you claim police power when you've created the problem? That how can you say things have gotten so bad, and then claim police power? And that's a challenge that I knew existed when I sat as chair of the conference committee. But because we were at a point of stalemate, that we had to move forward just to get to this point. And so if I read the tea leaves correctly, and if you look at the Conover decision, you look at the oral arguments and the questions of the justices who did ask questions, I would say that we will be back at the negotiating table to try to determine what we do about solving our crisis with regards to the pension liability that we have.
Okay, so when you say back at the negotiating table, can you elaborate a little bit on that, please?
Well, maybe back at the negotiating table is not a good term, because we never really fully went to a negotiating table. It was, there were some of us in the Senate who liked one proposal, and there were some in the House who liked another proposal. We were at a stalemate, and we went to a conference committee, and there were some negotiations in the conference committee, but it wasn't such that all stakeholders were at the table. I think when you start talking about the being consistent with the pension protection clause of the Constitution, and you talk about contract doctrine, modification cannot take place without the mutual assent of the parties, right? So the stakeholders have to be at the table. If you and I have a contract and we're going to modify it, we both have to agree to that modification. It can't be unilateral.
Well, good afternoon. I'm Michael Kerrigan. I'm president of the Illinois AFL-CIO, speaking on behalf of the We Are One Illinois Coalition of Unions. We represent the teachers, police, firefighters, nurses, caregivers, correction officers, child protection workers, snowplow operators, highway maintainers, and hundreds of thousands of others, both active and retired, who serve the people of Illinois each day. Workers and retirees didn't cause this problem. Over a lifetime of service, they paid into their pensions out of every paycheck. But politicians failed to honor their own responsibility. We are seeking justice to right the wrongs of politicians who shirked their responsibility, first to pay their part and then to uphold the Illinois Constitution. We are fighting for the modest life savings of working people, for the integrity of the Constitution, and for the basic principles of fairness. Working people and retirees who earn modest pensions and always paid their share shouldn't be punished for the failures of politicians. Make no mistake, we arrived here today due to the failure of politicians to pay their own part. In fact, it's happening as we speak. The governor pushed for the expiration of the 2014 income tax rates, resulting in tax breaks that disproportionately benefit wealthy people and corporations. Now he's pushing for extreme pension cuts, in effect, to pay for those tax giveaways. In November of 2014, the Circuit Court ruled that SB 1 was unconstitutional and void in its entirety. Having concluded our argument in front of the Illinois' highest court, we believe they will agree that this pension theft litigation is unconstitutional.